All right, this is another emergency rule, in this case from the Department of Safety, filed on August 3rd, and will remain in effect for 180 days unless replaced by a regular rule. In this particular case, Section 385, Chapter 91, which was House Bill 2, appropriated Department of Safety $200,000 to be used for the purpose of funding additional part-time instruction or increasing the tuition discount provided New Hampshire emergency service personnel for certain programs, and to do that through administrative rulemaking. And that's the rule you have before you today. Again, there are two grounds for emergency rules: imminent peril to public health or safety, or substantial fiscal harm to the state or its citizens. And in this particular case, in item number 8 of the cover sheet, it wasn't entirely clear which ground the department was selecting. It appears to be imminent peril to public health or safety, but you can see by looking at the emergency rule itself that a substantial discount is being now offered under this emergency rule for tuition fees for what's called Firefighter 1 and Firefighter 2 certification courses. And the department's here to explain the emergency nature of this. One point I would bring out in their summary, these courses, the first of them would be available this month. Subject to a new law, you can actually use interim rulemaking, but that would not have been available for the committee to review until next month. So you're really talking about that distinction between August and September as the basis for the emergency rule. But as I said, the departments here can explain it further.
Marta?
So it's true. As a result of the budget, we had research of money that was applied to the tuition reduction for the towns to be able to send candidates to the academy. And we currently have classes on that.
Yes, thank you. We currently, throughout the state, we have one firefighter, one class, 4 firefighter, 2 classes that are starting. And this additional money to take advantage of this classes this fall, so cost substantial back to fire responders for the state. We have one local department.
Okay, so this is a good thing. Any questions from the committee? Thank you. Department of Business and Economic Affairs.
Hey, yes, sir. So these rules provide funding to tourist groups, chambers of commerce, and others for the promotion of New Hampshire to increase tourism. There are 6 substantive comments left to review.
Excuse me, Kim, you'll have to speak up or be more distinct. We can't hear you in the room.
For us old people.
Okay. So like I was saying, there are 6 substantive comments to review. The first one is on page 6 of the linked PDF or page 1 of the rule. The first one is an informational note letting you know that these rules actually expired prior to the abolishment of DREAD and that they were transferred over to the Department of Business and Economic Affairs. The committee may have some questions about enforcement under the rules since they were expired or are expired. The next comment is on page 8 of the linked PDF or page 3 of the rule. Here, this comment, there's also a comment on the bottom of the, or in the middle of the page, regarding the use of will. It needs to be changed to a shall. At the top of the page, there's a comment regarding the language in the rule around the submission of the application. The rule notes that the application deadline will be specified in the application itself, but upon review of the form, there is no deadline within the form. It could be that there are multiple deadlines, maybe rolling deadlines each year for the submission of these grant applications, but there's no rule language to indicate that. We did send some language over to the department to consider some examples of how they could remedy this situation within the rule. The next comment is on page 9 of the linked PDF, page 4 of the rule. Just need to scroll down there. Okay. So the form contains a certification that's actually not within the rule, so it needs to go into the rule. On the next page, there's a reference to a deadline for filing additional information, but it's not really clear whether or not the reference deadline really is applicable to the submission of the application because it's about whenever they need additional information. The final comment is on the last page, page 12, and that's the comment that you've been seeing during the pandemic, and that's around the remote public hearing. Those are the only comments with this proposal.
Is anyone here from Business and Economic Affairs? Well, somebody should report that's an error in judgment on their part.
If I may, Mr. Chair, we're dealing with expired rules, and I'm just disappointed that there isn't a sense of urgency from not just this department and many, because as we all know, they have no ability to enforce the laws behind the rules when they expire, and it's just troubling to see this, and hopefully that gets transmitted to the departments in this department.
Yes. Discussion? We want to try a motion?
I would move we preliminary object to the rule on the grounds noted by the staff and the lack of support by the department.
Second.
Discussion? Seeing no discussion, all those in favor?
Aye.
Opposed? Pesticide Control Board.
Okay, so this proposal makes changes to the rules around pesticide applications. There are 3 substantive issues remaining. The first one is on page 10 of the linked PDF, page 3 of the rule. So here, there's a reference to a regulated list maintained by the U.S. Department of Agriculture, Animal and Plant Health Inspection Service, but it's not clear whether or not the intent is to incorporate this material. No incorporation by reference statement has been filed in this case, and there's no appendix. Also, there's no website to indicate where folks can actually go to find this list. So it's not clear what the intent is there. The next page has a comment at the top of the page, and it's informational, just letting you know that the department does have authority to require liability coverage insurance. And then the last comment is on the final page, and that's around the remote public hearing.
Introduce yourself.
David Rousseau, Director of Division of Pesticide Control.
Your comments on the staff comments.
On the first point, the identification of the list is the intent is to identify, not to incorporate. The certification registration behind it, the license, is for government employees in regards to control of invasive species and regulated species. There is a list identified by the state by statute, and then the second list identified is the United States Department of Agriculture list of regulated species. We only have one individual that actually holds a certificate of registration. It's a government employee. Again, the intent is not to incorporate, but just to identify that that list exists. We do have a memorandum of understanding with the United States Department of Agriculture when we involve ourselves with this work as a partner. The preference would be to keep the language as it is. If not, we could, if it's amenable, we can certainly remove the identification of the list, because as a government protocol, we have to follow that. Would you like me to continue on the second point in regard to insurance, or address the first comment?
Do you have any comment on the comment?
No, that was an informational note, just letting you know that they do have authority to require the liability and coverage.
Okay, go ahead.
The second point is in regard to insurance. It's in regard to chemical liability. And the point made is to whether or not the board actually has authority to identify financial assurance. In the pesticide control statute, as the language is in front of you, it does support proof of financial responsibility in amounts to be determined under rules.
Okay,
And I believe the last point was the public hearing was held remotely based on the time frame and the allowance to hold such a meeting.
okay.
Mr. Chair? Yes, I think it's important that we clean up the reference to that list because we don't want to have it be hanging out there as something that the members of the public are expected to follow. So I don't know how you would reword that to say what it is. But I think it needs to be clear that it's a list that you're keeping track of and that the public doesn't need to worry about it. If that is the case.
Yeah, that actual certificate registration is for a government employee only, not for the public or private industry. It's an individual that would work for the government in control of species. And so that by protocol, you have to follow that list anyways.
So
And if there were a website, does the U.S. Department of Agriculture publish this on a website that you could place within the rules so that folks know where it's located?
Certainly.
okay, fine. I move to approve with the condition that that fix be made.
Second.
Motion made and seconded. Any discussion? All those in favor?
Aye.
Any opposed? Thank you. Board of Acupuncture Licensing.
Okay, so, all right, so there are just two substantive comments on this proposal. The department did file a conditional approval request that removed all the other issues. There is a comment regarding the remote public hearing on the last page, and then on page 4 of your linked PDF, there is a comment there. And we've seen this a lot from some of the boards from OPLC in that the application deadline goes beyond the 60 days allowed in 541A29. The committee has previously approved extended deadlines for applications submitted to licensing boards because the extension provides applicants with additional time to complete their application. But in this case, while the deadline isn't within the rule itself, it is noted on the form that the board has up to 120 days in total to act from the filing of a completed application. As the form states that the board must act on the completed application within 60 days, but if there's additional documentation needed, then they will need to have another 60 days. So that's really the only substantive issue with this proposal.
Department's comment on,
Yeah, so that's not part of the form. We do put there's a cover letter that goes with the form that we put on the website, and it's with the form under one link, but it's the cover letter and not the application itself. And it does say 60 days and 30 days.
Okay, it still is notifying individuals that there is an extended time period beyond 541A29.
Sure.
But as I previously stated, this extended deadline has been repeatedly approved by GELCAR for other licensing boards because it is seen as being, good for the applicants to have that extended time to present their material to the board.
So it would be for the applicant to be able to submit the additional information.
is this a particular problem for this
If I may, this is for the executive director on professional licensure. With 5.1A 29A has been interpreted by the Department of Justice about 30 days upon receipt of an application or certainly a complete application. The office has to notify the applicant what's missing. Then the applicant has however long they want, and it could be indefinite to respond. Upon receipt of a response, which is not necessarily a completed application, the board must act within 60 days unless granted by license. We would support obviously any changes that would require boards to act within the 60-day requirement, but certainly I think giving the applicants longer term information that has been requested, it's necessary. We don't receive applications that are complete probably about 85% of the time.
You do?
We do not. Most applications we receive are incomplete, which is why it takes so long to process, leads to inefficiencies. We receive applications in piecemeal fashion.
If I may, Mr. Chair, that if 85%, if I may, of the applicants come back incorrect, to me, that indicates there's a systemic problem there. And is it with the applications, the way they're formatted? Why does this happen? I mean, the application should be clear, self-explanatory, and functional. It doesn't sound like we have that.
Well, I think it's a combination of many problems. The first is that a lot of the boards require information from external sources that are outside the applicant's control, such as transcripts directly from university or board certifications directly from an entity or an FBI background check. So while they may fill out the application and they may pay the fee, we're still waiting on information from multiple different sources that technically is missing and it doesn't allow the office to process that application. So that I think is the large majority of the issues. We have recently updated our website with video to better improve communication to licensees. We've created FAQs, specific checklists as to what needs to happen in order to submit an application. But a certain number of applicants are just never going to follow direction.
Thank you.
Have you considered reducing the number of requirements so that it is less of a burden to fill out?
Well, the office certainly has encouraged boards to review their regulations and their rules, but obviously the office doesn't control what the board's requirements are. They have independent regulatory authority, and I can't speak for what the board of agriculture licensing has chosen.
And I came into this towards the end, so I don't know what theirs are, but I know that all the boards at present are reviewing what their requirements are. We're working with them to make sure that what they're requiring actually goes to the competency of being licensed and not undue burdens.
Thank you. It's good to know that.
Anybody offer a motion?
Mr. Chairman, I have a question.
Go ahead.
Thank you. So how is this being handled? If the police background check, for example, is one of the holdups, you can't approve somebody if that's hanging out there. By the same token, the applicant, as you previously stated, does not control that situation. So you don't approve it. In the meantime, that person is hanging, twisting slowly in the wind, I believe is the phrase. So how are you handling it? Are you tentatively approving it at some point, but following up so that if the background check fails, that you yank the license or what?
So there are a number of ways that we've tried to come up with a temporary interim solution for these applicants. It obviously depends on what the requirements are in particular practice act. One of the things that we did last year is we got legislative authority to issue temporary licenses from the office if you have a license in another state. So we are continuing to issue those temporary licenses, and we're doing so in about 24 business hours. Unfortunately, for new applicants, they don't qualify because they don't have a license in another state.
inspections and medical technicians is one that allows us to issue a temporary license pending the FDA background check. But a lot of professions do not, it's a requirement of statute, there's nothing. We are working with our agency partners on pharmacy safety, just launch the portal for the licensing boards, and so those boards that do have FDA background checks now for the portal, and we are.
Thank you.
Any other questions from the committee? Looking for a motion.
Move to approve.
Second.
Discussion? All those in favor?
Aye.
Opposed? The motion carries. Microblading certification.
Okay, so this is these are new rules to implement House Bill 70 from this previous session. These are interim rules. There are 4 main substantive issues. See, the first issue is on page 1 of the rule, page 5 of the linked PDF. And this is around some language that OPLC, or the board rather, is using. The title says license, and throughout the rule, there's a few places where they're referring to a certificate as a license. Admittedly, a certificate may act like a license, as it is a form of permission, but the statute uses the term certificate. So that's one issue. And it's sort of closely related to the next one, which is on the next page, on page 2 of the rule, page 6 of the linked PDF. And that's the establishment of a $110 licensing fee for permission to do microblading. House Bill 70 established the ability for licensed cosmetologists and estheticians to receive a certificate for microblading, but the bill didn't specifically establish any fees around that. So it's not sure whether or not there's actual authority to require that fee. And there are some outstanding issues around forms. There are 3 forms that are mentioned in the rule, but they haven't been submitted. Like I said, this is an interim rule, so when they go through regular rulemaking, I would suspect that we would see those forms. And then the final issue is on page 7 of the linked PDF. And here is just the rule is unclear. It's saying that, that these folks will bandage according to industry standards, but it's not real clear which industry standards are being referenced here, whether that's body art, microblading, or cosmetology, or something. So I think they just need a little bit of language there to specify what that means. And those are the issues.
Go ahead.
Okay, I'll speak to the first issue, which is the intertwining of the term certification and licensure. We intend to clean that up so it just says certification.
Okay.
With regards to forms, we are developing forms, and we will have those ready for we'll go through the regular rulemaking process. With regard to fees, I'm going to let Lindsay speak on that.
Thank you, Lindsay Courtney, Student Director. I agree that the statutory authority within 314A is a little unclear. We do have statutory authority and statutory corrective in RSA 310A, which was recently modified, obviously, and it specifically requires the executive director of the OPLC to assess annual or biennial license certification as any necessary. So I think the statutory authority is clear. With the board, the advisory board was looking at this. I think that there were cases related to government time, which is pretty severe. It's already set in statutes. We do have that authority. I did want to note for committee that the legislature very soon just went through a complete analysis, changed our allocation methods. So we will be seeing some rules for all boards consistent with the authority granted to us in RSA 310A. And so in any event, it's possible that it's likely be incorporated into that.
Questions from the committee?
I have a question, Mr. Chair.
Go ahead, Peter.
So this is a process that is, in my view, inherently dangerous because these people are breaking the skin on the face. And so I'm very concerned about whether this is a bill that came before House ED&A. I had numerous discussions with practitioners. I think it's extremely important that the oversight and the rules be as seamless and as comprehensive as possible, because to the degree that you have skilled professionals doing this procedure, I think it can be done safely, but I'm very worried about the possibility that people are not sufficiently trained or experienced, and that if you get into a person's face and you get an infection or a bad job, that permanent scarring or other very unfortunate medical outcomes are a possibility. So I want to go on record as saying that I hope that this oversight is going to be extremely rigorous, and I want to be kept informed with regard to the numbers of people and what the training programs encompass. Thank you.
If I may respond, thank you, Representative. I had shared your concern, and I continue to share the concern regarding what are the minimum qualifications. A number of states require the 100 hours, which is a standard course, in addition to the apprenticeship. Unfortunately, I don't think apprenticeships are possible given the workforce and the backlash that we've had in the body art industry of not wanting to offer apprenticeships to estheticians and cosmetologists. And I think if we instituted an apprenticeship program, it would result in nobody actually being able to receive the certification. So what we have proposed is an interim rule. We are going to monitor it. Obviously, we continue to receive, if we receive a large number of complaints, then I think we're going to have to reassess requirements.
Yes, thank you, Mr. Chair. I noticed that the number of hours for the proposed training has more than doubled since our initial discussions a couple of years ago. And they've added the bloodborne pathogen training as well. I'm concerned that I've had requests from a number of estheticians who have been trained and working in other states who are very anxious to get such a license. How quickly will you be able to process them since you don't have the forms yet?
So I think the requirements are set forth in rule, and we can institute an internet application in accordance with the requirements that are set forth in rule. Regarding the 50 hours, I wasn't privy to that part of the discussion, but I would say we looked at what are the courses that are actually being offered. There are the canned courses, so to speak, that are being offered nationwide are 100 hours, and they include this one.
Fine, I will reassure my constituent that she can send in all her data, and you will process the certification immediately.
Yes, and these shouldn't take too long to process because they don't require information from external sources like the FBI background checks.
Okay, thank you.
Other questions or a motion?
I'd like to amend that to conditionally approve to incorporate the fixes on the confusion between certificate and license.
Yeah.
That's okay with you, Senator?
Thank you, Representative.
Second,
I'll second.
and a second. Any discussion? All those in favor?
Aye.
Aye.
Any opposed?
No.
We have one opposed.
I want to be recorded as a no vote on that.
Okay, we'll show that Representative Schmidt was the no vote. Board of Veterinary Medicine.
Okay, so at the committee's meeting in June, the OPLC agreed to, the rule was conditionally approved, and part of that conditional approval was the OPLC agreed to make some changes to the definition of veterinarian technician to include veterinary nurses and veterinarian assistants. But when the board met to finalize and vote on the conditional approval response, it realized that including veterinarian assistant within the definition of veterinarian technician was going to be problematic because those two types of designations, they don't have the same level of education. So the board voted to finalize the conditional approval response with some additional language that was not agreed to at the committee's meeting in June. When they did so, they knew that making that change would result in a preliminary objection running all the way back to the date of GLCAR approval, which was June 18th. The board then filed the board was required to file a preliminary objection response by August 2nd, which the board did meet. They filed one. The issue here is that 541A13 doesn't address whether or not the board was procedurally required to vote two times, once on a conditional approval response and then once on a preliminary objection response. As the statute doesn't specifically state that filing a conditional approval response could serve as a preliminary objection response. That pretty much summarizes the procedural issues with the filing. And now the committee needs to decide whether or not they can approve.
Your voices are not going out on the streaming.
If you don't mind, Mr. Chairman, if you could speak clearly into all the microphones, because the streaming isn't picking it up, so the folks outside the room can't hear you and it can't be recorded. And Scott also has a wireless mic available, I believe. So if there's a problem, you can use that wireless mic as well. Key your mic, there's a switch on and turn them on and off. Speak clearly into the microphones.
Clearly and slowly.
Bring the mic closer to you. Long
Yes.
enough for the light.
Mr. Chairman, I think it's important for the record to note that the problem is the background noise is insurmountable under the terms and conditions of people wearing masks. And so I think this is intolerable action.
Okay, when you're not speaking, it also helps if you turn your microphone off, so it doesn't pick up all the spare noise. Okay.
Okay, so I guess I'll summarize what I just said very quickly, was that the board decided that including veterinarian assistant within the definition for veterinarian technician was going to be problematic because of the educational requirements are different. So they voted to not to do that and to make the change that you see in front of you on page 7 of the linked PDF. So there's a procedural issue here, which is whether or not the conditional approval response could have served as the preliminary objection response, or whether or not there needed to be 2 votes. The board did intend their conditional approval response to serve as a preliminary objection response. They knew that their conditional approval would convert to a preliminary objection. That said, you have I think now what the committee needs to decide is whether or not they can approve this change that is different than what was conditionally approved back in June.
Scott?
Can I do that under 541A? What's being asked? I don't know if that's appropriate or not.
Could you repeat your question again?
To approve this now, it's not a standard preliminary objection response. Is it okay to accept that under 541A? I'm just looking for your guidance on that. Thank you.
Yeah, certainly, you could do that. The issue, of course, as Kim explained, was that the agency wanted to make a substantive change to the rule that the committee had not conditionally approved. If you're happy with that change, then you can just approve the objection response.
Are you speaking on behalf of the?
Sorry. Yes, the board had looked at that, and there was a miscommunication between myself and the board because I came in late into the game. And by having one definition for all, it increased the what a veterinary assistant could do based on the education. They weren't educated enough to be able to be under that definition, so we had to split it into two definitions.
So if I may, Mr. Chair, considering that, I move for approval.
Motion to approve. Second. Discussion. All those in favor?
Aye.
Opposed? The motion carries. And can we get a brief explanation of the emergency rule?
Okay. This is an emergency rule filed by the Board of Veterinary Medicine on July 15th. It will remain in effect again for 180 days. The basis for this emergency rule, first of all, adopts VET 403.01 on continuing education requirements that actually expired as an interim rule at the beginning of 2020. As explained in item number 8 of the cover sheet, the board lays out the basis for the emergency rule, explaining that this is actually due to the end of the state of emergency in June. On January 29, 2021, in emergency order number 29, Exhibit Y, the governor had authorized all boards under the Office of Professional Licensure and Certification, such as the Board of Veterinary Medicine, to allow all continuing education to be through remote instruction until 30 days after the state of emergency. Well, when the state of emergency ended, all the emergency orders were terminated. So as a result of that, the board has adopted VET 403.01 on continuing ed. It's actually a short rule. If you scroll down and see it, there is one change from the rule that had expired as an interim rule in the beginning of 2020. In this particular case, it's a sentence that says the board will accept virtual continuing education programs. In other words, the board is trying to replicate by emergency rule what had been granted through emergency order. But again, it only lasts for 180 days. The justification by the board is that veterinarians for whom renewal is due on December 21 will be unable otherwise to obtain sufficient in-person credit to be able to renew their licenses. This will result in approximately 1/2 of the veterinarians in the state no longer be able to practice and would create what they call an immediate peril. They meant imminent peril to the health and safety of all animals and the public. And other than that, I don't have anything further regarding this emergency rule.
Thank you. Any questions on the emergency rule? Let's go to Board of Dental Examiners.
Okay.
And we have 3 emergency rules.
Yes, we can take the first 2 together because they're actually very much alike.
Get close to that microphone, Scott.
We can take them together because they're very much alike. The first one deals with application for licensure by dental hygienists. In this case, this too actually as a result of the end of the state of emergency. Emergency order number 29, Exhibit N, in July of 2020, amended the rules of the board due to the absence in the pandemic for the opportunity of performing clinical examinations on a live patient. Instead, they would be able to be done on a mannequin. And the particular dental rule here that's in question was actually cited in the emergency order. Again, that order expired on December 21, 2020. Emergency order 29, Exhibit Z, reestablished it in April of 2021. And with the end of the state of emergency, so went that allowance for clinical examination procedures to be done on a mannequin. In this particular case, the dental board has again adopted an amendment that would allow, along with or as an alternative to the American Board of Dental Examiners dental hygiene exam, a mannequin examination for applications submitted since the end of the state of emergency. And this rule will remain in effect until January 11, 2022. And so the board will have to readopt it in that time. Now, the same issue occurs with the next one, this time for applications to be dentists instead of dental hygienists. Same issue, being able to work on a mannequin in an examination instead of a live patient. The rule regarding application for dental licensures has exact same amendment as for dental hygienists. And again, with the exact same purpose, so that dentists seeking renewal could be able to accomplish that without having to use a live patient. You may wish to ask the board about the scope of the shortage of, in this particular case, examinations with live patients in order to determine the extent of the imminent peril. It's not quite clear, for example, how many dentists or dental hygienists are going to be impacted were there not an emergency rule.
Lindsay?
Thank you, Lindsay Courtney, Executive Director, OPLC. I don't have a specific number. I will say that throughout the COVID-19 pandemic, obviously testing with live patients ceased completely. It created a backlog of particularly dental hygienists seeking to take their exams, and the only thing that they were waiting for to get licensed and to get into the workforce was the exam, which prompted the emergency order allowing them to conduct testing on mannequins. Again, that emergency order expired, and I think the board thought that everything was fine. But again, there was a shortage of people being able to test, and then it created another backlog, particularly with dental hygienists, which prompted the second emergency order. I do not believe that the board intends to pursue regular rulemaking to keep this in place. This was specifically created for those who took the test in 2020 and 2021 so that they can obtain licensure.
Thank you. Any questions? In the manner of payment of anesthesia, sedation, inspection fee.
Okay. Again, another emergency rule from the dental board. In this case, as you can read from the rule itself, when it comes to, as it says, requirements for inspection or evaluation fees, third-party fees shall be paid directly to the Office of Special Licensure and Certification at the time of scheduling of the facility inspection or comprehensive evaluation. That replaces language relative to payment directly to the third party at the time of the facility inspection or comprehensive evaluation. In their explanation for the emergency rule, they explain that that's what third-party fees used to do, or used to be paid to. And it says, in order to ensure fair and efficient administration, the collection and processing of fees would be more appropriately handled in advance and separate to the inspection and evaluation by the Office of Special Licensure and Certification, which is ready and able to assume this responsibility. It says, without the enactment of this emergency rule, there's a threat of both substantial fiscal harm to applicants due to inconsistent fees and imminent peril to the public health or safety due to the inability to complete the comprehensive evaluations and facility inspections. In item number 9, the effect of if the rule were not adopted, it says if this rule were not adopted, fees would continue to be collected by the inspector at the time of the inspection, which can lead to inconsistent practice and appearance of potential impropriety. The issue here is regarding the emergency rule, is that it isn't clear how this all leads to imminent peril to public health and safety. It's a great reason for a rule. It's not entirely clear that it meets the grounds, however, for an emergency rule.
Thank you. This rule came about as a result of the ongoing LBA audit into the Board of Dental Examiners. Specifically, there are some things that have been brought to our attention that need to be immediately addressed. One of which is how the board has been apparently handling inspections for the moderate sedation permitting. The statute is really unclear. It permits third-party consultants to conduct these inspections, But in practice, what the board had done is created through rulemaking a committee to advise the board on rulemaking, which then, without really authorization from the board and knowledge from the board or the office, created a subcommittee which was going out and doing these inspections, and were actually acting as state agents, not third-party consultants. So the office has immediately, obviously, addressed the situation, and with the board has disbanded the subcommittee. At present, we need members of the committee to continue to go out and do inspections, but because they are state agents, because they are appointed, they do not fit the definition of third-party consultants. We need to set the payments through a PLC. There will be another filing shortly. The payment needs to be the same, and it needs to be handled on the up and up through the office, which is the basis for this emergency filing. If this emergency rule does not go into effect, or it is in effect, but if this emergency rule was not in effect, we are not doing inspections right now. And as a result, we're not issuing permits because the process that was taking place was not acceptable.
Bill?
Unless I missed something. Is there, does it need to be a legislative fix for this? Does that get pursued?
Yes, there absolutely needs to be a legislative fix. You know, I've been talking to DOJ, the LBA, the board about what that should look like. From my perspective, I think what we're going to pursue is do an RFP and likely just hire a consultant. I would prefer that route because you can manage the contract and what's happening through the contract, and there's no concern about people in the same business, which is very small, 30 or 60 people inspecting, potential competitors, which is another concern here. So we just haven't determined what the precise fix should be, but there definitely needs to be legislation that will be seeking this legislative session.
Okay.
Okay. The last emergency rule today is from the Board of Nursing Home Administrators. In this particular case, they're amending an existing rule regarding continuing education to renew the registration by a nursing home administrator, reduce the number of clock hours from 40 clock hours over a 2-year period to 20. This relates to, in fact, the COVID pandemic, and indirectly to the end of the state of emergency. The agency explained in its justification for the emergency rule that the COVID pandemic necessarily caused cancellation of continuing ed programs. And even though the state of emergency ended on June 12th, the agency states that continuing education programs remain largely unavailable still. And by reducing the 40 clock hour requirement to 20 clock hours, the hope is, it says that nursing home administrators will be able to obtain sufficient clock hours continuing to qualify for renewal over the next 6 months. Otherwise, they wouldn't. The concern is stated in the justification of the state of, for the emergency rule is that this problem would result in a large proportion of nursing home administrators no longer being able to perform their essential roles, creating an immediate peril to public health and safety. And I have no explanation further than that. The committee may wish to ask how going from 40 to 20 will address the imminent peril by not having enough renewals. And for that matter, how many administrators are going to be affected by this? How many are coming up for re-registration? And whether the availability of continuing ed programs is now improving at this point, either through remote instruction or otherwise.
Thank you, Lindsay Courtney, Executive Director of PLC. Yes, this was an emergency rule promulgated by the board. I can tell you that we received a lot of feedback, particularly from the Healthcare Association and nursing home administrators, that they are not going to meet qualifications for renewal. There's already a workforce shortage, particularly in nursing homes, but that includes nursing home administrators, which has led us to have to issue emergency permits during COVID-19. I think even a loss of 1 or 2 out of our 115 or so that are licensed is very problematic for the state. And certainly I think that the board's decision to reduce continuing education on a limited basis, limited time frame is going to alleviate that concern.
Carol?
Thank you. My question is, if 20 hours is good enough for this year, why isn't good enough going forward? Why should this rule expire?
I would agree with you, Representative. I think that the standard should be, the minimum required to ensure somebody is competent. That's something that we're going to look at with the boards, and we're constantly engaged in that conversation with the licensing boards.
Other questions? Thank you. We're now going to take a 5-minute break, and then we'll come back and do the interim rule on the Education Freedom Accounts program.
That's somebody else who didn't believe you'd be on time. Lori Harnold.
Who?
Lori Harnold from Travel and Tourism. The rule that nobody showed for.
Shame on them. I told Scott, I have a time for all these years. Schedule everybody at 9 o'clock. They're paid employees. And they gotta be somewhere. And when we're in the other place, I said, there's offices, phones, computers. And we can come and get them. Okay. So just as a reminder, this is not a policy committee, and we do not decide matters of policy. We work with enacted statutes that have ordered somebody to write rules, to enact the statute. If you disagree with the statute, you must find yourself a legislator who will sponsor legislation to change the law. That's the only way you can do that. You can't do it here. So we're going to get an explanation of the rule, and this has been a complicated rule in a very short time period. It's been back and forth between the JOCAR staff and the Department of Education, and it's been a hard go. It caused the people in education to have to work last weekend, and the JOCAR staff people work 7 days a week anyway. So we'll proceed with the presentation on the rule.
Okay, this is a proposed interim rule to implement the Education Freedom Accounts program. The interim rule will, if approved, will be effective for 180 days. The statute, the originating statute was part of the recently passed budget bill. Our comments to the interim rule as filed were nearly 70 in number. The board has filed a conditional approval request, which you do have linked on the agenda. And that conditional approval request nearly addressed all the issues in the rule by deleting language rather than attempting to fix the language to address the comments. And really, a lot of the comments could not be addressed because of the ambiguities in the originating statute, RSA 194F. There is a large text box on page 10 of the linked PDF, which outlines the problems with the statute that may need to be addressed during the next session to avoid those same issues coming up whenever the board moves forward with this regular rulemaking proposal. In the conditional approval request, there are about 30 comments, substantive comments. Since there are so many, I'm not going to go through each one. There are comments that could be resolved in regular rulemaking. There are comments related to the implementation of the rule or the program. And there's simply just not enough information in the rule to understand how things will be performed, how it will be done, which can lead to oral rulemaking in violation of RSA 541A22. The department has been given a broad grant of authority, but in a lot of places has chosen not to exercise it by removing the rule language that was unclear rather than amending it and kind of fleshing that out. It could be, since this is a brand new program, that there are just many practical matters that can't be hammered out just yet, but should be addressed during regular rulemaking. So I think the main thing to do here is to focus on the large text box on page 11 or 10 of the linked PDF as well as a note regarding the potentially inadequate fiscal impact statement. So I'm going to do that now, and then Mike has a few comments that he was going to bring to your attention as well. So if you look on page 10 of the linked PDF, there's a note regarding an potentially inadequate fiscal impact statement. So the FIS says that costs or benefits are attributable to the statute and not to the rules, which may not be entirely accurate. There was no fiscal note attached to the budget bill, House Bill 2, providing an accurate assessment of the state's potential financial impact to the implementation of the program. And the department did not provide that fiscal analysis that it provided to Senate Bill 130 in the last session to the LBA in its fiscal request to the proposal. The LBA's fiscal analysis was based on this, on the department's request, which stated that the proposed rules would have no impact to the political subdivisions or to the state citizens, and that any impact is a direct result to the statute. It didn't indicate that if the interim rules were not adopted prior to the start of the school year, that there would be a financial impact to students, potentially causing financial hardship. Additionally, the FIS request did not include the cost of obtaining potential criminal background reports, which I'll talk about in a moment. So that potential cost wasn't identified if that is required. While RSA 194F4 Roman 5 caps the revenue to the scholarship organization at 10% annually from the EFA accounts, there's other potential administrative costs to providers, to the organization, to participants that should have at least been mentioned in the FIS, even if it's indeterminable. The only cost to the board that the board identified was to the scholarship organization for the development of a technology interface. And there is a note there that the JOCAR's authority to object to a proposed interim rule around the fiscal impact doesn't specifically include the ground of inadequate fiscal impact statement. But the JOCAR may object to a proposed interim rule if it determines that the rule is contrary to a legislative intent, including violations of 541A5, Roman numeral 1, that the agency provided inadequate details of the intended action. So then the next comment is around the note for the need for legislation to basically clean up the statute. So the originating statute 194F defines a scholarship organization in a singular, not a plural fashion. And the statute itself is written as if there's just one organization. The interim rule as filed anticipated multiple organizations. And so it's not really clear if the department had that authority to do that. The rule also, the interim rule also talked about a parent and education service provider advisory commission. The statute did set one up, but it set up one commission, not multiple commissions as was contemplated in the original filed interim rule. And it's also not clear whether or not the provisions of 91A apply to this commission, since it was established by statute by the legislature. The statute also talks about that EFA funds shall not constitute taxable income that may conflict with federal tax law. If the legislative intent was to allow more than one scholarship organization, the statute may need to be clarified. And it may need to be clarified whether or not the requirement to have a standardized form will be applicable across multiple organizations. The statute also permits subcontracting for certain services, and it doesn't require GNC approval to do so. We're not completely sure if it needs to. If it does, then the statute may need to be clarified. The statute doesn't really address the role of the Board of Education, and oversight by the department, according to the statute, is pretty minimal. They do have a pretty broad grant of authority. And as I said earlier, the conditional approval request removes basically all oversight, probably because some of that needs to be fleshed out. You see the roles of the Board of Education and the role of the department may need to be fleshed out because the statute grants the scholarship organization authority that is typically given to an executive agency, and it may represent an impermissible delegation of authority. So let me see, the statute also only grants the department rulemaking authority necessary for administration of the statute. So any policies or procedures that the organization develops are not going to have the same authority as they would if they were administrative rules. There's no provision in the statute to require that these education service providers have a criminal background check. Initially, the rules sort of proposed that. It wasn't specific. It didn't say a criminal background check. It said a background check. So it's not really sure if that needs to be inserted into the statute. The statute does not address any protections needed to keep confidential personal student information, including healthcare information, which it may possess. The initial filing did have some language around that. The conditional approval request removes all the requirements to develop protocols to protect confidential student information. So again, the statute may need to be clarified. The program specifically bars payment for homeschooling, and if the legislative intent was to permit that under the program, again, the statute may need to be clarified there. Scholarship organizations are approved by the Department of Revenue under RSA 77G1 and G5. The rule currently in the conditional approval request appears to give the commissioner of the Department of Ed the ability to suspend or remove a scholarship organization for participation in the program, which there's no clear authority in the statute to do that. But there's certainly no authority by the Department of Ed to remove the scholarship organization's designation as an approved scholarship organization under 77G, because that is the purview of the Department of Revenue. So those are some of the issues that need to be clarified in this statute. And I will turn it over to Mike.
Thank you. I just want to raise a few points, specific rules regarding comments. As Kim had noted, there are a number of clarity comments, but a lot of them are minor, and a number of them can be addressed through during the regular rulemaking process. There were a lot of comments on the interim rule initially. The department did a very good job addressing those, or trying to address those. In doing so, though, they did create some new issues with language. I do want to apologize to the department for whatever reason, which is still unknown to us. We finished the comments on the conditional approval Tuesday afternoon, and they were supposed to go out immediately to the department, but apparently they didn't get them until earlier this morning. So they are somewhat flying by the seat of their pants. But if you turn to pages 1 and 2 on the conditional approval request, at the bottom of page 1, there is a definition in N of qualifying differentiated aid eligibility. There are a couple of comments there about that, but my concern is with the second sentence, and I've done a comment on the next page. The sentence says a pupil with a qualifying disability as defined under 34 CFR 300.8, which is attached, as determined by a medical professional licensed to practice in any state. We're not sure, the staff is not sure what is intended here. Under RSA 186C2, it references school districts making this determination, and under 34 CFR 300, it references public agencies, meaning schools, to determine whether a student is disabled for education purposes. So we're not sure what's going to be happening here by allowing a medical professional to do this, and we're not even sure what is to be considered a licensed medical professional. I'll turn it over to the department here so we can do these one at a time.
Good morning. My name's Amanda Phelps. I'm the Administrative Rules Coordinator for the Department of Education.
And I'm Chris Bond, attorney for the Department of Education. Okay. Sure. So first, I'd like to just thank the OLS staff for their quick turn of these comments. It is a complicated rule, as Senator Reagan noted, so we appreciate your prompt attention. Also, to the general idea that we responded to a lot of the comments by removing them, I just wanted to clarify that the board does intend to start a regular rulemaking in September. And so a lot of those concepts that were removed from the rule, we will probably revisit and attempt to address the staff comments on those. But the reason that we felt comfortable taking them out for the interim rule is that we already have a contract with a scholarship organization that will take us through the interim rule period. So for example, confidentiality protections are addressed in that contract. So that's why we felt comfortable not having those in the interim rule. In a permanent rule, of course, we will need those kinds of protections because we don't know about some future scholarship organization, but at least for the period of the interim rule, we felt that we had adequate protections in the contract language, and so could launch the program without clarifying those things, and we could work them out in detail through the regular rulemaking process. As to the particular question on the bottom of page 1, the purpose there is not to define for any specific educational purpose such as IDEA or benefit or access to services. It's only to clarify that that process is designed only to clarify that an EFA student is eligible for the differentiated aid that is specified in 190-40-A. So the department thinks it's implementing the clear intention of the statute, which is that an EFA student would get the adequacy funding that otherwise that student would have received had they been in a public school. And this is a way to capture those students who would have had an EFA had they been in front of a public agency or a public school or been to a public school and would have been designated as having a need for services, for example. So it's only to specify the amount of differentiated aid they would be entitled to. It's not intended to entitle them to any special ed services. It's not intended to make any sort of IDEA determination.
Sorry, thank you. Moving on to page 5 of the conditional approval request. At the very top of the pages in paragraphs C and D, under 194F, parents are allowed to pick textbooks and curriculum. We're concerned about how this works in practice because the rules talk about possibly that not being carried out, or if it is carried out, we're concerned, what if the education service provider doesn't use those textbooks or that curriculum, or particularly in a situation where the student is in another school district, they reside in one school district, but for their EFA, they're going to another public school in another district. If the parents are picking out the textbooks and the curriculum, how is that going to work with the other school district, which establishes its own curriculum and textbooks?
Yes, thank you. So the department's understanding of this language and of the statutory intent is that the parent has the ability to direct the EFA program. And that includes choosing curriculum and choosing an educational provider. However, the educational provider doesn't have any obligation to provide curricula that it doesn't already have. So the parent, if they select a particular education provider, can select from among the curricula that provider provides, but they don't have any entitlement to compel that education provider to provide additional curricula. The parent, though, as an EFA, or the student as an EFA student, can incorporate additional curricula outside of that particular education provider, but they don't have any authority. We don't interpret this rule to mean that they have any authority to compel an education provider to provide additional curricula.
Sorry. Moving down page 7. In paragraph H, second paragraph on the page, it talks about the scholarship organization creating a parent and educational service Provider Advisory Commission. As the statute is worded, the statute creates the commission. However, it is a scholarship organization that appoints persons or the director of the scholarship or organization that appoints the personnel to this commission. So we thought the rule was unclear based on comparing it with the statute. And that is something that could be cleaned up in regular rulemaking.
Certainly, yes. And again, as you noted, we're just responding to these comments in real time essentially here, but I don't see a problem with that frame. And certainly will take that comment under advisement in the regular rulemaking to clarify that. I don't think that we have a problem with that.
Okay. Further down on page 7 in 324.11, A, C, and E, which carries on to the next page. On the first, on the interim rule itself, you can see the words and substantial have been inserted in the conditional approval request. Initially, it said intentional misuse of funds. We pointed out in a comment that the statute says intentional and substantial, so that's what the department put in. However, substantial is a very vague word, and it's not how this will be carried out, particularly if there ends up being more than one scholarship organization. Are they going to have a consistent method of implementing this? One of the purposes of rulemaking is to implement and clarify statutes, and staff believes that substantial should be clarified. Again, this could be done during regular rulemaking.
Yes, I think we will definitely address that during regular rulemaking, and certainly appreciate the comment that if there are multiple scholarship organizations, then the need for consistency is very important. So we'll definitely look at clarifying that. And the department has some ideas about some language that could do that.
Okay. Further down on page 8 in paragraphs M, N, and O, which go on to the next page, there is a concern about what activity the commissioner can take against the scholarship organization. Certainly, I can see that if the scholarship organization was doing something wrong, committing fraud or whatever, that the board and Department of Education would want to prevent that scholarship organization from going forward in handling EFA funds. But the scholarship organization is approved under 77G. That is done by the Department of Revenue Administration, not the Department of Education. And I'm concerned with the way this is worded. So when the scholarship organization is no longer approved under 77G, well, that would be no longer approved by DRA. Then the commissioner is going to issue a written notice of non-compliance. It seems like that's something that DRA would do. I think this sort of combines authority of the DRA with authority of the department and the board, and maybe that needs to be separated and clarified. Because if you look further down in, like with paragraph N, commissioner shall immediately suspend the scholarship organization's eligibility where health, safety, or welfare of student is at risk. Again, does the department have the authority to suspend the scholarship organization? Probably not, but it seems like they could take some sort of action to prevent the scholarship organization from continuing to handle the funds. But that could be clarified in regular rulemaking, and perhaps something could be added to the statute regarding the commissioner's ability to take immediate action. Right now, that says that the scholarship organization shall have 15 days from receipt of the notice to file a request for a proceeding with the department. I mean, to the extent that giving approval to the scholarship organization by the DRA is a form of permission required by law. Then under 541A, it's considered a license, and you can't take it away for immediate reasons of health, safety, or welfare unless you follow 541A. I don't have 30 Roman 3, which requires that there be a hearing within 10 days if this is going to be an adjudicative proceeding. That's an open question, I guess, as to regarding whether this is a license or not. And that was it. Any questions by the committee?
Question from the committee. Senator Whitley.
Thank you. Thank you, Mr. Chair, and thank you for being here and all your work to the department and to the John Carr staff. I know this has been a lot of back and forth, and we see you, we recognize you, and thank you for all the work. So I'm wondering if we could just sort of flesh out this notion of, taking some things out of the conditional approval request because it's already in the contract. And, that does make me a little bit nervous because we haven't seen the contract, right? And so I think we do have due diligence as this committee to really explore those issues so we feel comfortable because this is an interim rule, this will be implementing the program. So I was hoping we could explore that a little bit further. And so specifically, if you could address the protections that are in place for the scholarship organization to protect student and family confidential data. If you could provide us more information on that, please.
Sure. So the contract has confidentiality provisions, essentially requiring the scholarship organization to treat information that the department would treat confidentially. And that's, again, totally understand that going forward when we're outside of that contract, it'll need to be clear in the administrative rule. But for now, the department is comfortable that it has these contractual obligations in place around confidentiality, and the scholarship organization that the department has contracted with already administers the scholarship program and has for several years, and they've have a good track record of maintaining that student confidentiality and of the records that they maintain as part of that program, which are in fact quite similar to the data that they will get under this program.
Another question?
Follow up.
Okay. The other question was related to special education rights. And so I know this has been explored by Attorney Zellin on behalf of the special ed administrators. So I'm wondering if it's the department's position that a family waives all special education rights when participating in this program.
Thank you. That's actually something that I think, and as I read Attorney Zellin's letters from this week, there is one question that the department I think is still working through is whether when there is a placement, a parent placement by an EFA student in a public school that is outside of their residential district, whether or not IDEA rights attach. Attorney Zellin's position seems to be that that would be considered a parental placement, and therefore IDEA rights would not follow that student. The department's not opposed to that interpretation, but we just have the humility to recognize that that's not really our call because the IDEA is not our statute to implement. So we'll be working with our federal partners as we develop the permanent rule to make sure. One of the reasons for some of the language that was in the original proposal that was then taken out was around this issue. We need some clarity from our federal partners about how that will be interpreted. But generally speaking, a parental placement outside of the assigned school district means that you don't have a right to a FAPE under IDEA, but you don't sacrifice all your IDEA rights. There are child find rights and additional rights that will continue to follow those EFA students.
Follow up? And what about those rights under 504? So those children who don't maybe qualify under IDEA, but do have a disability that needs some additional support.
Yeah, 504 is obviously, as you know, distinct from IDEA, and the 504 rights generally do attain with other education providers. Because the EFA program is much broader than just schools, there may be education providers that wouldn't have 504 obligations on them because of the nature of the services they're providing. If someone bought a curriculum program from somebody but wasn't attending classes or something like that. But generally speaking, the 504 rights are, in a broad sense, more portable than IDEA rights.
Last question, thank you. And then in terms of, our non-discrimination laws, we've done a lot of work in New Hampshire to improve protections, particularly for students. So is it what's the department's position on whether the ESPs need to comply with all those state and federal non-discrimination laws?
I think if memory serves, there's statutory language that the ESPs do need to comply, but that's answering off the top of my head. So yeah, I think it's my understanding that ESPs would need to apply with any applicable state or federal non-discrimination provisions in the implementation of or the offering of the services.
And can you find that statutory provision? Because it was unclear to me.
I could try to get back to you with that, but not at this moment. No.
Okay, thank you.
Senator Prentice.
Thank you. Thank you.
Oh, excuse me, Senator Whitley, I do have a reference, 194E6, Roman numeral 2C, requires compliance with all state and federal anti-discrimination laws.
Thank you, Chair. May I proceed? Two questions.
Proceed.
One thing, again, good morning, everyone, and thank you for all of your work as is well recognized here. So you, in answering a question to Senator Whitley, I believe you said the special education statutes didn't apply here, but you would be coordinating with the federal partners. How did you, there was a.
Yeah, so let me clarify, and let me also just state that I'm not an expert on special education law. We do have program people who could probably answer these questions in more detail than me, but okay. I can speak to my understanding. I didn't say that special education laws didn't apply, but there is a standard and well understood in the special ed community concept where when you do a parental directed placement outside of your assigned public school, there are certain IDEA rights that no longer attach to you. That is an established thing. And I think what we're trying to work on with our federal partners is understanding, because there are school choice laws around the country, but New Hampshire's is unique among them. And so what did the feds think of this situation where a child is a parentally placed child, but in a public school receiving public funds to go to that school? What do the feds think that means for whether those IDEA rights follow? And I think we don't have perfect clarity on that yet.
Okay.
That was my point. And again, that's my understanding. We have people that are far better versed in it than I who could maybe address that if you want to follow up with us.
Okay, great. Thank you. And my second question has to do with education service providers, and I'm looking for clarity around background checks. So in 324.08, it talks about education service providers, application form shall include but not be limited to. So if I'm reading this correctly in item number 1, well, now 1 is crossed out. So it's but it says if any used by education service provider to background check employees. So are education service providers required by the department to have their employees who will be again interfacing with children and families, are they required to have background checks?
So if I'm understanding the question correctly, do education service providers have to provide background checks to participate in the program? Our understanding, based on our draft rule, no, they're not. But I think for context, it's important to point out that the concept of an education service provider is very broad. So many of the, I apologize, thought I had that on mute.
No, it's all good.
So many of the education service providers will not have direct interaction with children. A lot of the education service providers, they can be schools, but they don't have to be schools. Now, to the extent that they are schools that are either public schools or non-public schools, those schools in New Hampshire already go through a certification process that does require certain background checks for people that have interactions with students. So it doesn't apply across the board to any education service provider, because an education service provider could be, a company out of state that's only going to mail curricular materials into the state. And so there's really no background protection or background check nexus there. But certainly if anyone's attending a non-public school or a public school in New Hampshire, those schools will have to have met all the ordinary minimum standards that the department has for those kinds of education service providers.
Well, follow up. Thank you, Chair. So just for clarity, you're saying the education service providers that are already in place in the state of New Hampshire already have this requirement, whether they are public or they are private? They are a school. If they're a school.
If they're a school, then they need to comply, public schools need to comply with the Ed 300 rules, the minimum standards. And then there's similar type rules for non-public schools in the Ed 400. So that isn't necessarily all education service providers, because you could get different education service providers that wasn't a school. But yes, any school. I don't know if there are schools in New Hampshire that are operating that are not approved by the Department of Education. I suppose that's possible, but if there is such a school, then a child who's enrolled there would be considered truant. So I think as a practical matter, there probably aren't. I'm not aware of any.
Okay, I'll hold for now. Thank you.
Okay, let's hear from Attorney Zellen and see if he can provide some clarity on the special ed.
For the committee, although you have Mr. Attorney Zellen's materials in your packets online, we do have paper copies up here if you wish to have them.
Jared, go ahead.
Oh, thank you. Thanks. I know you want to jump right to the special ed issues. May I just spend just about 3 minutes on the big picture to lay a context?
Yeah.
Okay, thank you. I'm here representing the New Hampshire Association of Special Ed Administrators, which is the statewide organization for public school and special ed private school administrators. The big picture includes the following elements. And I'm not here to ask you to amend the statute. The statute is what it is. And we recognize that what you're here to do is to adopt rules to implement the statute. But though these are just temporary interim rules, there are many websites that are already urging parents to apply for these EFA scholarships. And forgive me, I'll call them vouchers. I hope that doesn't offend anyone. Once a government benefit is bestowed, we all know that it's difficult to pull it back. People justifiably rely on it. And so we need to get these interim rules right the first time, even though they're just interim rules. Also, importantly, the statute itself, RSA 194F, is very vague on just what the rules must address. Specifically, RSA 194:F, Roman numeral 4, Roman numeral 15 says as follows, quote, "The department shall adopt rules that are necessary for the administration of this chapter," period, unquote. That's it. So I do think that these rules can clarify the statute and fill in gaps in the statute, especially where, without filling in those gaps, the statute might be constitutionally suspect as delegating too much authority to a private organization to make up the rules, or as regarding the separation of church and state. And I'll also note that, and forgive me, I'll use the word target here, I don't mean it pejoratively, but this has been a moving target for me and the organization I represent. We had the proposed rules dated July 15, and then on Monday, I obtained a copy of the conditional approval request, which was a significant rewrite. And now I understand that Jalkar has critiqued the August 16 draft, which I haven't seen yet. Now turning to the points that I raised in my letter. First of all, and this to me is very important for the protection of students and parents, as well as everyone else who's working with the system. The proposed rules delegate to the scholarship organization not only the duty to notify parents of what special ed rights they forfeit, but also for this up to the scholarship organization to identify what other rights that parents forfeit. And I'm hearing the State Department of Education is saying, well, it's going to be working with its federal partners to answer just what rights parents will forfeit if a special ed child then gets a voucher. And I think parents are entitled to that notice up front, so they're not buying a pig in the poke. But I'm also concerned that the decision on what rights parents will forfeit is going to be made by the scholarship organization when it's creating this notice of rights. So I think we need for the State Department of Education to be drafting the notice of what rights parents forfeit. And I think the State Department of Education, when making that decision, should be making it in a forum where different stakeholders have input to perhaps point out how the State Department of Education's position is mistaken and violates state statute or federal law. But I'll leave it at that. My letter elaborates a bit on the many layers of rights that the special ed laws confer and how some may be lost by EFA students and some may not be. Point two, the state and federal laws establish a process for identifying a child as eligible for special ed. And I rejoice that the New Hampshire Department of Education's attorney is saying that this provision in the proposed rules that goes outside that process, that allows a medical doctor to identify a child as eligible for special ed, is solely for the purpose of allowing that child to get more funds from the Education Trust Fund. It will just simply, as I understand it, not only allow that child to get the adequacy aid the child would ordinarily be entitled to, but also the $2,000 of differentiated aid that attach when a child is identified as disabled under the special ed laws. Well, if that's the case, then that's not going to hurt school districts unless the child then returns to the public school and the parents say, well, I have this bogus identification of special ed eligibility. It won't hurt the district short of that, because the district, having never identified the child as special ed eligible, was never getting any differentiated aid for the child to begin with. But it will have a fiscal impact on the state, because it means that in practice, that the parents will go out to doctors. And of course, we all know doctors like to say yes to their patients. And the doctor will say, yeah, I'll write up this letter saying your child has a disability, not going the extra step of looking at the other prong of IDEA eligibility, which is whether the child, as a result of the disability, requires special education. So we'll have doctors willy-nilly writing these notes that will allow children who ordinarily would not qualify for special ed to be identified in order to get the differentiated aid, and that will cost the state, not school districts. Lastly, and I agree, I'm getting on thin ice when I say don't amend the statute. But I think that it's so important that if we can find a way through rulemaking to clarify the statute, we should do so. And that is the fact that the EFA statute does not recognize how it interacts with another statute, RSA 193:1-c, which enables any child attending a private school to go back to the public school part-time. And under this scheme, under 194F, unless we clarify it through rulemaking, if a child is going to the public school part-time and then going to an EFA program part-time, the school district is stripped of all of its adequacy aid. If the child's special ed eligible, stripped of all its differentiated aid, and yet the school district incurs costs providing services to that child. And that's terribly unfair. It's a case of someone trying to have their cake and eat it too. They're taking all the EFA funds as if they're withdrawing from the public school, and yet it allows parents to go back to the public school part-time. And this can have enormous consequences for the school district if the child qualifies as disabled under Section 504. Because if the child's going back to the public school part-time, the public school has to provide, while the child is there, reasonable accommodations and modifications to comply with Section 504 and the Americans with Disabilities Act. And those reasonable accommodations and modifications can sometimes be very expensive. In extreme cases, they might include a one-to-one aide. They may include a one-to-one nurse when the child's on a field trip or whatever. And so I think it's terrible to strip school districts of all their adequacy aid when they continue to bear that financial burden. And that when I say it's unfair to school districts, I don't mean this amorphous entity. I mean the taxpayers of the school district, and I mean the non-disabled students in the school who have no entitlement to any particular amount of resources. And so the more a school district spends on the EFA students who are coming back part-time, the less the school district has for the other students who are not EFA students. There's a final point I did not address in my letter, but I think it's important to point it out. And that is that the EFA program is giving away public money, but there's no public oversight of who the money goes to or what it goes for. And the reason why I say that is that the EFA statute does not ask the State Board of Education to approve a school or a vendor that would be eligible for EFA funds. Instead, the statute delegates to the scholarship organization, a private entity, which apparently doesn't even operate under the right to know law. The statute delegates to the scholarship organization the duty to approve providers. And that's in RSA 194-F:6 Roman numeral 1. But then when you look further into the statute, RSA 194-F:2 Roman numeral 2 lists the sorts of EFA services that funds can be spent on. Those are the guardrails for the scholarship organization. But how wide are those guardrails? That provision in the statute contains a long list of items that the scholarship organization can spend money on, but ends with the following, quote, any other educational expense approved by the scholarship organization, unquote. So that's delegating to a private agency what categories of services and what sorts of vendors will be spending public money on. And that gives the scholarship organization, a private agency, unfettered discretion to dole out public funds.
You're in a policy area now, Jerry.
Okay, it's true. And I'm hoping that through rulemaking, you can fill in the gaps to remedy these policy and constitutional delegation problems, because I do think that the EFA statute, when it addresses the scope of allowable rulemaking, is flexible enough to permit that. So thank you very much for your time. Thank you for your public service.
Jerry, thanks for your expertise. And the JOCAR fully expects the Department of Education in their regular rulemaking to conduct other public hearings so that they can absorb all this information. And I'm sure you will be in attendance at the hearing.
Yes.
Representative McGuire for a motion.
Yes, thank you. I move with the conditional approval request with the additional point that the department work with the legislature on correcting the ambiguities in the statute, that they begin regular rulemaking as soon as possible, and that the Department of Education be required to review and approve the statement of rights given up.
Second.
Discussion? So I was hoping to ask Attorney Zellin some more questions, but I do feel at this point that because this is such an important program, because there's such potential fiscal impact on the state, because these are involving our children, that we just don't have enough information here in the interim rules to do our job to, one, ensure that the statute can be implemented. That's our job here, right? We don't have enough information to do that. So because this is an interim rule, this is the only opportunity for public input on this version, but this version will be in place until probably February, right? So I think that based on the problems identified by the jail car staff, which in my limited experience, these are the most concerns I have seen. There were over 70 concerns with clarity alone. So based on those alone, and then you compound these additional issues that Attorney Zelen had identified, I think we have at least two bases here for a preliminary objection, not just one. We only need one to support a preliminary objection, but we have two here. One, that this rule, this interim rule, although we know that the folks have worked really hard on it, we just don't have enough information to know how it will be implemented and whether they will be able to implement it consistent with the statute. So that makes this rule contrary to the intent of the legislature in a variety of ways. And that's not in the public interest. I think on the latter point, the jail car staff has identified how unclear these rules are. I think we had some more clarity in the first version of the interim rules, but with the conditional approval request, even though we were told that this is all in the contract, I haven't seen the contract. So I have an obligation to the public to do the due diligence to make sure these protections are in place. I don't have that assurance. I'm also concerned that, because these rules are even more unclear than the first version, of course, we don't know how they're going to be applied. We don't know whether there's going to be a uniform application of these rules. That's really problematic. And it's most problematic with all of the delegation of authority questions that were raised with the scholarship organization and significant questions about the breadth and the scope of their role in this program, their authority to manage public funds, and their protocols in place for accountability. So what I'm saying is that we don't have enough information about these issues in the rules. They were taken out of the proposed rule. I'm also concerned that the conditional, like I said, the conditional approval request does remove this language, and thus it removes practically all oversight and gives even less guidance or clarity for implementing the program. I think that, another thing that we really need to consider here is whether this interim rule and the conditional approval request, whether it actually meets the requirements of 541A, right? We heard significant concerns about the fiscal impact statement. I'm almost done. Thanks. So I don't think that the fiscal impact statement meets the requirements of 541A, and that makes it contrary to the intent of the legislature. Again, these are public dollars. We're giving away public money with virtually no oversight over a private entity that won't be subject to our right to know law. Look, even regardless of your poly position on this program, we can't violate public trust and allow a deeply flawed program to be hastily implemented without adequate protections, without adequate scrutiny by this committee, which we are, sat on this committee to do. So we have an obligation to our constituents, to the public, to our children, to do that adequate scrutiny. That's why I can't support this motion. Thank you.
Thank you, Chairman Reagan. So I too cannot support this motion, and I'll briefly tell you why. I believe it is our job as legislators and as this group to be good stewards of public interest and public funds. The basis for my concerns here have to do with the lack of oversight, definition, and clarity, which can I just list them out? That were talked about today. I understand, Senator Reagan. Scholarship organizations, background checks for education service providers, the special education issues that were raised, and as Senator Whitley pointed out, the lack of the potential here that I'm hearing more than once of not being subject to these private organizations to right to know laws when they're receiving public funds. So those are my objections. And they relate directly to rules that were discussed today. Thank you.
Thank you, Mr. Chair. The objections I've heard so far deal exclusively with policy. The legislature spoke, the governor spoke, the people spoke. These issues of rules can be done in permanent rulemaking, and I will be supporting this motion.
Can I respond to that?
Mr. Chairman? The question regarding the motion. I believe the Vice Chair said conditional approval based on staff annotations to the conditional approval request, plus a recommendation that DOE work with the legislature regarding statutory clarity. And I believe there were two other conditions that I did not get.
The first is that they begin regular rulemaking as soon as possible to resolve all these other issues. And secondly, that the Department of Education review and approve the statement of rights given up, because that is something that, as Attorney Ellen said, the department knows a lot more about than the scholarship organization.
I just wanted to clarify something for the record, please, Mr. Chair.
Go ahead.
So I just want to clarify, as Representative Roy identified his characterization that our objections were based on policy. That's not the case. You know, as I indicated, you know, there are 4 potential bases for an objection for proposed interim rule under 541 A19, and we have 2 here. We have B, contrary to the intent of the legislature, and 2C, determined not to be in the public interest. And I identified in my comments how that completed our objections based on those 2 different bases. Thank you.
Bill, question?
Thank you, Mr. Chair. Just briefly, though it's, just to premise the question I have, though it's not uncommon to have concerns addressed, concerns of conditional rulemaking to be addressed in regular rulemaking. I've never seen quite this many to be addressed in that manner. And if they go forward as they are, the consequences. So my query is, if there has been stated urgency for approval of this rule, but if this conditional approval does not pass, what is the time frame, or what, and I guess I'll ask staff this, what are the consequences of that? How quickly can these, well, how quick can this be addressed? What's consequences for that?
Next school year.
Yeah.
Okay, if the conditional approval motion does not pass, then you can ask for another motion. You could ask for a conditional approval motion on with other issues. Representative McGuire's motion had a number of recommendations, for example. You could make a preliminary objection instead. Or you could technically take no action. You do have a deadline, however. The deadline to act on this interim rule is not until November 3rd. If you took no action, unlike final proposals, if you took no action on an interim rule, then they can't adopt as an interim rule. They can always file another interim rule, but not this one. So those are your options. If the conditional approval motion does not pass, then the committee is open to any other motion.
I had another procedural question, if I may. I have another procedural question, if I may. Thank you. Because this is an interim rule, this is the only opportunity for public hearing. I didn't know if there were other folks that wanted to provide public testimony. Great, thank you.
Okay, just one statement, Mr. Chair, because it's something Representative Roy mentioned is how he would vote. He wasn't here when the meeting was convened, but you have all 10 regular members. So those are the only members that are eligible to vote at this point.
Yes.
No.
No.
Yes.
Yes.
No, you have a continued meeting scheduled at this point for September 2nd. You can cancel that if you would like. And under those circumstances, your next meeting is your regular meeting on Thursday, September 16th. And otherwise, the committee can adjourn.